So let's start with lasting powers of attorney. So statistically, 45% of people aged 45 and over don't know what a lasting power of attorney is. So don't worry if you fall into that statistic, or if you don't, great. But if you do fall into that statistic, hopefully by the end of this webinar, you will know what a lasting power of attorney is. And then worryingly, every 90 seconds, someone is admitted to hospital in the UK with an acquired brain injury. And we're going to look at the importance of lasting powers of attorney being in place for people who have suffered an injury or are unwell and in hospital. So before I move on to the lasting power of attorney, I want to talk about something called a general power of attorney. So a general power of attorney is a very basic document. It's usually 1 or 2 pages. It's executed as a deed, which means it's signed by the person giving the powers, and we call that person the donor. It gives information about what powers the donor is handing over to somebody, and it has to be signed by a witness. So it can be very wide reaching. I did one at the weekend actually for a family friend, which was very wide reaching. My friend's mum's in hospital and she's not sure if she's going to need for her house to be sold, for her children to manage her bank accounts for this short period of time while she's in hospital. So it's a plug the gap document that only lasts for a year. It can be limited, so we can tailor it to say, I want to appoint these people just when it comes to the sale of my house. And importantly, it's automatically revoked by the mental incapacity of the donor. So this isn't about the donor giving away any power. It's about appointing people alongside that donor to make decisions with them and on their behalf when they're not able to, because then they're in hospital, or sometimes we have clients who are away with work or on oil rigs, but they've got a property sale that's going through. So that's when we would use these documents. And although they are very powerful and very useful, it does rely on the donor retaining capacity. I'm sorry, it says relies on the attorney retaining capacity, though. It should say relies on the donor retaining capacity. So I'll share these slides and amend that before they're shared. So it's a really good stopgap while we're waiting for a lasting power of attorney to be registered. And I'm going to go on to explain that it can take some time for the lasting powers of attorney to be registered. And so if we need something immediately, these general powers of attorney can be a good little plug the gap stopgap. So lasting powers of attorney, what are they? So lasting powers of attorney replaced enduring powers of attorney. If you have an enduring power of attorney, or you know someone that has an enduring power of attorney, they are still legally valid documents, but we can't create those anymore. Now we can only create lasting powers of attorney, and it's quite a rigorous process to create a lasting power of attorney, and rightly so. It's an area that is open to abuse, and so we have to make sure that the donor, the person who is giving powers, is properly protected, but also the attorneys, the people who are acquiring powers, are appropriately protected as well. So anybody with mental capacity can create a lasting power of attorney, and it's a legal document that gives any individual over the age of 18 who has mental capacity, the donor, an opportunity to choose a person or people they trust, we call those attorneys, to make decisions on the donor's behalf if he or she loses mental capacity. And there are 2 different types. There's a property and financial affairs, and a health and welfare lasting power of attorney. Both of the documents can only be used once they have been registered by the Office of the Public Guardian, which we abbreviate to the OPG. So I'm going to talk about the registration process. I'm going to talk about the 2 different types of lasting powers of attorney as well. So as I've said, anyone over the age of 18 who has mental capacity can make a lasting power of attorney. And when we measure mental capacity in law, there are different thresholds for the production of different documents. So the threshold to be able to produce a will is quite a low threshold. That's testamentary capacity. And then capacity in this context means the donor is able to understand and make decisions for his or herself. And this is at the time of making the lasting power of attorney, so at the time of signing. The donor must understand the process of making the lasting power of attorney, why they are making it, and the likely outcome. And if there is a question mark about that mental capacity, we can meet with the donor face to face and provide our professional opinion. If we have concerns, we may involve a medical professional for an independent capacity assessment, or there are certain types of social worker that have additional qualifications that allow them to undertake the capacity assessment. So generally, if I think the situation is borderline, I'm going to be suggesting that we have somebody with a medical qualification to provide their opinion as well, as a second signature to it. But if I'm happy that the person creating the power of attorney does have the requisite understanding and that there's no undue pressure or influence, that they understand why they're doing it and what's going to happen when they do it, then I can act as the certificate provider. That means that I have the relevant expertise to say this is all above board and it can go ahead. It is possible for people to create lasting powers of attorney without using a solicitor, and the person who is the certificate provider there is someone that has to know the donor and know them well for a period of, I think it's 2 years, it might be 3 years, but it can't be a family member or anybody else that's named in the power of attorney. So if the proposed donor is found not to have capacity, so if I say I query the mental capacity and then the medical professional agrees and says, I don't think we have the relevant level of mental capacity here to proceed, then we have to consider an application to the Court of Protection. And the way that I think of the Court of Protection and the Office of the Public Guardian is that they act for the same type of people and look after the interests of the same type of people, but they're on opposite sides of a corridor. So the Office of the Public Guardian are there to protect and to monitor powers of attorney and donors and how people are acting when people have capacity. The Court of Protection are there when people lack capacity and they are under the protection of the court. So what are the pitfalls of not having lasting powers of attorney? So being married does not give the other spouse any right to do things like access their husband or wife's sole bank accounts or pay bills in the husband or wife's sole name. We've probably all been in that situation where you're on the phone to somebody on somebody's behalf and they say, can we speak to the account holder? And that's all well and good when the person's there and you can pass the phone to them and they can remember their full name, their address, the date of birth, the 5,000 characters of their password. But I struggle to do that myself with the passwords. But where they can't, because they lack capacity, you, as a spouse, you can't automatically stand in their shoes. Whereas a power of attorney, if it was in place, could have conferred those powers to the spouse so that they can keep things ticking over whilst the donor doesn't have mental capacity. Many people think of lasting powers of attorney as being documents for the elderly, which of course they are in a lot of circumstances, but sometimes that can be too late. So sadly, events like accidents or strokes can occur at any age. And in those circumstances, it's shutting the gates after the horse is bolted. We need a power of attorney in order to be able to help the donor and for things to carry on as normally as possible. But we've left it too late, because once that person's lost mental capacity, there's nothing that we can do other than go to the Court of Protection. And again, if someone receives a diagnosis of something that we know is going to be degenerative to mental capacity, such as dementia, that might be the trigger to sort out their affairs. So along with all the medical things that need to be thought about, often people's minds turn to the legal side of things, and that includes lasting powers of attorney. However, sometimes depending on the progression of the condition, it may be too late by this point to execute lasting powers of attorney. So we need to have the initial telephone consultation, we need to arrange a face-to-face meeting. Sometimes we need 2 meetings to be able to take the instructions, verify capacity and get the documents signed up. And you're looking at the availability of anyone that's caring for the donor, the availability of the donor, the availability of the solicitor. So it's not something you can just pick up the phone and say, I want to put it in place today. It can take a number of days or weeks. And if somebody does have a degenerative condition, then we can find ourselves in a bit of trouble there, and it may be too late. And as I've mentioned before, the only alternative in those circumstances is the court of protection. And the reason why I'm reluctant for anyone to find themselves in the court of protection is, one, it's expensive. So the court fees are expensive, the solicitor's fees are expensive, and it takes a long time to get the application through to the court of protection for a deputy to be appointed. And rightly so, a judge has to adjudicate on the person making the application, the needs and wishes and feelings of the person, in this case called P, so the patient, the person that we've been referring to as the donor. So who should be appointed and for what powers should be conferred to them. There's also an ongoing reporting process with the court of protection, so you have to do annual returns. There's insurance that has to be taken out to protect the patient, so the deputy has to pay for insurance, which can be expensive, and any big decisions such as the selling of a house or the change of investments, every decision has to defer back to the court of protection. So it's incredibly useful when we don't have anything in place, but it's not really, because of the bureaucracy and all the administration, it's not really an arena that we want to be in if we can avoid it. Okay, so property and financial affairs lasting power of attorney. We'll deal with this one first, and it does what it says on the tin. So it means the attorney, so the person appointed by the donor, can deal with any decisions regarding the donor's property and finances, including things such as managing, buying and selling the donor's property, paying household bills and managing the donor's bank account. So an example that I'll give to you here is, say that there is a parent who has always gone to the shops at the weekend, taken their money out at the cash point and then gone and done their shopping and then come home. And they're finding that more and more challenging. So a child, son or daughter, offers to help. So they give them the bank card, they go and take the money out of the account because mum or dad's given them the PIN number. Then they go and they do the shopping as normal, and then they bring it home. And this is all agreed and this is fine. But we all know that really that shouldn't be happening. It's happening with consent, but actually the person putting in the PIN number doesn't have legal authority to be doing that. And that's all fine as long as we can check with the parent that they're happy for the child to be doing that. But quite often we find with degenerative capacity issues such as dementia and Alzheimer's that the parent can forget that that arrangement has been set up. And often we see, and it's sad to see, but often we see as part of these medical conditions a fear that the money is being taken from the donor, from the parent, and that they're losing control of their finances. And so when they see sums of money going out of the bank account and don't recall who they gave the authority to, it can put that child in a difficult situation with their parent, but also with other siblings who perhaps don't have the full picture. So we do say that having the powers of attorney in place are as much about protecting the donor as they are about protecting the attorneys as well. And it's about formalising those arrangements. And it's possible for the donor to restrict the types of decisions an attorney can make, or the donor can give the attorney authority to make all financial decisions on the donor's behalf. So an example here would be, I appoint my children to deal with the sale of my property, but not to manage my business. It could be, I have clients who have two different types of property and financial affairs powers of attorney. So they have one where they appoint the brother who is the co-director of their business. They appoint the financial director and another person within the company. So if they lose mental capacity, the business can continue to run without any hiccups. But when it comes to the management of the bank accounts, when it comes to the sale of the property or anything that's personal to them, they've appointed their wife and adult children because that makes more sense. So you can have more than one power of attorney for property and financial affairs, although it isn't very common. I'm just making the point that each one that's created can be for discrete assets, if that's a preference. Generally, what people do is they choose somebody that would be able to oversee everything on their behalf. So it's usual for people to just have one. But I just want to make the point that we can carve these powers of attorney to match the needs of the donor. So finance's lasting power of attorney can give an attorney authority to continue a claim on behalf of the donor if they lose mental capacity. So this could be that there's some pending litigation. We often see this with our personal injury clients, that they have started a claim, but then their mental capacity starts to deteriorate. If they have a lasting power of attorney in place, then their attorney can continue that legal claim on their behalf. And there is also an option for the attorney to provide instructions on behalf of the donor with the donor's consent, while the donor retains capacity if the donor wishes. So this is again for, it's geared up to talk about legal proceedings, but this applies more generally. So with the property and financial affairs with the lasting power of attorney for property and financial affairs, the donor can give instructions to the attorney to act on their behalf. So they could have mental capacity, they could be in another country, they could be unwell in hospital, or they could be just on holiday and don't want to deal with things. They don't have to have lost mental capacity for their attorney to be able to step in and act on their behalf. So they could say, listen, I'm in Scotland, please can you go down to the solicitor's office in Cornwall or the estate agents in Truro or wherever and deal with XYZ for me. And it's sufficient that that attorney has the lasting power of attorney and proof of their identity, and they can act on behalf of the donor. And that's quite an important distinction, that the attorneys can act both when the donor has mental capacity and when they don't have mental capacity. So it's really important that the attorneys understand the scope of their role and what it is that they're going to be doing on behalf of the donor. Okay, the health and welfare lasting power of attorney differs in this way, and it's the final point on this slide, but as I was just talking about it, I'll mention it now. The health and welfare lasting power of attorney, this can only be used when the donor has lost mental capacity. So the whole ethos behind the powers of attorney is that additional people are appointed to assist the donor. This isn't ever about taking any powers away from the donor. It's about appointing that safety network of people that can either work collaboratively with the donor or, in the absence of mental capacity, on behalf of the donor. And where the health and welfare lasting power of attorney and property and financial affairs power of attorney differ is that the health and welfare attorneys can only act if the donor is unable to make a decision for themselves. So what kinds of decisions can the attorneys make? They can make health and care decisions, such as whether a particular medical procedure is performed, what medication is administered, and what residential care setting the donor lives in. Now, it could be that all of these things are agreed and there's no conflict over this, but I'm sure we've either experienced ourselves or heard of people who have a strong wish about medical treatment. It could be that they don't want to have blood transfusions. It could be that they don't want to have any further chemotherapy. I had a lady once who she was sadly terminally ill with cancer, and it had spread to her brain, and she'd had years of bouts of chemotherapy, and she had been told that with this prognosis that she was going to lose a mental capacity, and she decided she didn't want to have any further chemotherapy. But because her children, the youngest just turned 18, if she weren't able to give instructions to the doctors, she knew that her children would be asked, and she didn't want that burden to be put on them, particularly as her instructions were to refuse medical treatment. So she appointed her best friend. And so she had that very difficult conversation with her best friend, but then her best friend was equipped with all the reasonings and all the legal powers that she needed to then be able to carry out that lady's wishes, and rather than that burden and responsibility passing to her children. So again, as with the finances power of attorney, it is possible for a donor to restrict the types of decisions an attorney can make, or give the attorney authority to make all decisions on the donor's behalf. So we talked about carving out responsibility for dealing with the house or the bank accounts or the business. This could be, I'm happy for you to make all decisions in relation to my upcoming surgery on my spine, or it could be, I'm happy for you to make all decisions in relation to my residential care, or in relation to my medication, or my care package, or whatever it is. We can tailor the wording so that it's specific to particular events or medical events or situations. And there's an additional power within the health and welfare lasting power of attorney. So we've talked about where people should live, who can visit them, what treatment they should have, but very specifically, there's an additional signature page where the donor can say if they're comfortable also giving that person the responsibility and the permission to make decisions about life-saving or life-sustaining treatment. So life-saving treatment we think of as usually quite major things like surgery, like blood transfusions, but it could be something as simple as a course of antibiotics. So it could be that somebody's very unwell with a poor prognosis, but actually they're in the moment, very unwell with pneumonia, and without the intervention of antibiotics, that they're unlikely to survive the pneumonia. Therefore, those antibiotics become life-sustaining treatment or life-saving treatment. And the donor can choose whether they are happy for their attorney to make a decision in those circumstances, or whether the doctors should make a decision, who are sworn to the Hippocratic Oath and to maintain and preserve life. So it's the closest that we get in the UK to right to die, which is this ability to give somebody the permission to make decisions about life-saving or life-sustaining treatments. And as I've mentioned, unlike the finances lasting power of attorney, attorneys appointed under the health and welfare lasting power of attorney can only make decisions on a donor's behalf when the donor no longer has capacity. So how do we make and register lasting powers of attorney? Donors can execute the documents themselves, but they can be complicated and must be signed in a specific order. So the process is the donor signs the document, and they have to sign that in the presence of a witness, and it also has to be signed by a certificate provider. So somebody who says that they have been through the document with the donor, that they understand the document. There's no reason why the attorney shouldn't be appointed. There's no undue pressure or influence, and then they sign off on that as a certificate provider. And that either has to be the same date or the day after the donor. Then the attorneys have to sign, and they can sign on the same day or the day after the donor and the certificate provider, but not before. So they have to sign in the presence of a witness who isn't the donor. And then if there are multiple attorneys, they all have to sign and make sure the dates are after that. And then the final page is the registration of the document, and that has to be signed by the donor, and that date has to come after all the other dates. And you can imagine when we're acting for a couple who are signing with their donor hats on and then with their attorney hats on, and the papers are getting passed around the table because the family are there, and then the attorneys sign. The dating of the documents causes us a real headache. So we are very careful to make sure that documents are tabbed up in a specific order, because if we get it wrong, there isn't any second bite of the cherry. It goes to Office of the Public Guardian, they'll reject it, and we have to start all over again. And particularly where we're dealing with mental capacity and degenerative mental capacity issues, we have to be really careful to get these things right. So you can create the documents and then just have them waiting in a cupboard for when they're needed, but we would always recommend that you get them registered with the Office of the Public Guardian, so that if they are needed, they can just be trotted out and taken to the hospital or taken to the bank or wherever they're needed. If the decision is made not to register them at the time they're created, you need to be aware that it takes 16 to 20 weeks to register a lasting power of attorney. And so it can often be too late to think, oh, we did those powers of attorney, where are they? Right now we need to send them off to be registered, and you're waiting 4 to 5 months before you actually have the powers that you need instantly. We do, as I mentioned, have that option of putting the general power of attorney in place as a stopgap. But if our donor has already lost mental capacity, then we can send them away to be registered, but we wouldn't be able to fill the gap with the power of attorney. So it's much better that you register the documents at the time they're created. And something that I know isn't on the slides, but that I should mention, is that at any time, provided they have mental capacity, a donor can revoke, so they can cancel their lasting powers of attorney, whether they're registered or not. I have one at the moment where the wife has contacted me to say that her donors are her husband and her daughter. Sadly, the relationship with her husband's coming to an end because he was violent towards her at Christmas. The daughter, for some reason, has sided with the father in those circumstances, and so she doesn't feel comfortable having them appointed as her attorneys. So we're going through the process of revoking those powers of attorney, and instead she's going to appoint her brother and her sister. So as long as the donor has mental capacity, we can always revoke and undo the appointment of attorneys for whatever reason. You don't have to give a reason. That was just to add a bit of colour as to the one that I'm dealing with at the moment. And as I've said a couple of times now, if a client loses capacity and does not have an LPA, or a donor loses capacity, does not have an LPA in place, then a deputy application to the Court of Protection will need to be made. And we can do that here at Irwin Mitchell. It just doesn't sit inside my team here. It's another team that deal with that and specialise with that. And a lay person can be appointed. So a family member can be appointed as a deputy, or we actually have a trust corporation here at Irwin Mitchell, which is a team of lawyers who are professionally appointed for individual clients, and so we make decisions on their behalf because we have those expertise in-house, so we can assist with that. So what is the solution? Make lasting powers of attorney while there are no question marks over your mental capacity or loved one's mental capacity or friends. Discuss your wishes with your chosen attorneys. You can spell it out even more to them by including preferences and instructions in the LPAs themselves. I had a gentleman who had a house, and behind it he owned some acreage, I think it was farmland or acreage or woodland behind him, and there were developers that had wanted to buy this off him for development for years and years. It'd been one of those things that he'd fought through his entire life, that was, this is my home and I don't want to be looking out on a new housing estate. So in his preferences and instructions, he asked his attorneys to dissolve all of his other assets if they needed to before they thought about selling off the land behind his house, because to him that was really important. So it was, make sure that you excuse me, tap into my shares or tap into my bank accounts or any other properties before you consider relinquishing the land at the back of my house. I had another lady who was a strict vegetarian, so she had it in her health and welfare power of attorney that she wanted to continue to have a vegetarian diet. I had another lady who had always worn trousers. She'd never worn a skirt, and it just wasn't her thing. So she had it that she didn't want to be put in skirts if she lost mental capacity and she was in a care home or wherever she was being looked after, that she didn't want to be there to be an assumption that because she was female that she should be in blouses and skirts, and she was very particular that she wanted to continue to wear the clothes that she had done when she had capacity, which is fair enough. And so we included that. So it can be preferences that are sort of wishes and feelings, or it can be more strongly worded than that. So it can be, as I've mentioned, with the disposal of land and assets, I instruct that you are not to dispose of the land at the back of the property until all other assets have been exhausted. And as already mentioned, registration with the OPG can take 16 to 20 weeks. So we say register your LPAs with the OPG as soon as they're signed, rather than waiting for there to be any issues with capacity. So just an indication of our fees. I have said that individuals can do this themselves through the government website. There are options to do this online, to print it off and complete it yourselves. But we would always recommend that you use a lawyer, because, in particular, because I've mentioned there are issues with the dates, the dating of the documents, and the mental capacity assessments. Our charges start at 850 plus VAT for a lasting power of attorney, but we don't then double that if you have 2, or triple it for 3, or quadruple it for 4, because we appreciate that we are repeating information as we produce the documents. And then each document attracts a registration fee of £82, which is payable to the Office of the Public Guardian. That isn't something set by us. That came down, actually. It used to be more than that. I can't remember how much it used to be, maybe just over 100, but then it came down to £82. And for people in receipt of certain types of benefits, you can apply for a fee exemption. So that's something available to some people as well. So as I said, I am Charlotte Pritchard from Irwin Mitchell. My contact details are on this slide here. I'm happy for those details to be shared, and perhaps Eva will do that after this call.